Welcome once again to Lehto's Law. Here's Steve Lehto.
If you've ever had the pleasure of serving on a jury or seen a jury trial and paid close attention, you'll notice that the jurors get instructions, jury instructions. And the jury instructions are handed down by the judge, and it explains to the jury how they should behave during the trial, what they should be doing, what they should not be doing. And what they should not be doing is important. So a judge will tell you, as a juror, until you go back to deliberate, for instance, do not discuss the case amongst yourselves. If you go home at night, don't discuss the case with your friends and relatives. Don't watch television coverage of this case, things of that nature. And in more recent years, they've actually added instructions that said, and by the way, do not conduct any research on your own, especially not on the internet. And they'll actually explain this because they've had problems with it. And so a story recently hit the news where a juror Googled an officer's mysterious uniform patch and was then charged $11,000 for contempt of court. And it's a crazy story. It's from Reuters, but it makes sense when you hear how it unfolded. Alison Frankel wrote it. The night before a federal jury in Camden, New Jersey began deliberating in a case accusing a man of assaulting an Immigration and Customs Enforcement officer, ICE, a juror was curious because during trial, jurors have been shown a photograph which showed a patch on the ICE officer's uniform. There was a suggestion that the patch may have looked like a trade union logo. And of course, it becomes an issue as to how confusing that patch was because the man on trial apparently was going to make the argument that he didn't understand these were law enforcement officers necessarily who he was dealing with, basically in his own home. So the juror, who was a retired pipe fitter, thought to himself, that does not look like a trade union logo. So he went and looked it up. He looked it up on Google. And then when he came back to court, he told his fellow jurors what he had found out on the internet by Googling the image that he had in his mind of what that patch looked like. He's now facing a fine of $11,227 after being held in criminal contempt by the court for defying the court orders and causing a mistrial. So they actually had to declare a mistrial and they have to try the case all over again. And the $11,000 is roughly what they calculated it cost for the first boondoggle. U.S. District Judge Robert Kugler of Camden imposed the fine after a show cause hearing, 2 weeks after the judge declared a mistrial in the case because of the Google search. And a show cause hearing is when the court has questions about something and they want to know why you did or did not do something. They'll bring you in and say, explain to the court, show cause why you shouldn't be held in contempt. Because there's no question, there was a jury instruction that said, do not do internet research about this case. This juror appears to have gone and done internet research about the case. And worse, told the other members of the jury, here's what I found. And by the way, that's how the court found out what he had done. Because one of the other jurors narked him out. This is one of the most extreme punishments ever handed down by court to a U.S. juror for breaching court instructions prohibiting internet research. This is according to John Browning of Spencer Fane, who has written extensively about jurors and juror behavior, along with social media and the internet. Judges in the U.S., according to Browning, have typically punished jurors with fines or community service, kind of make them think about what they did, even when their Google searches or social media posts have resulted in mistrials. In case you're curious, a juror in the UK was sentenced in 2011 to 8 months in jail. But in that case, the juror was corresponding with the defendant on Facebook during jury deliberations in the defendant's trial. Now, this big New Jersey penalty, according to Browning, represents an attempt to have the offending jurors fined for contempt at least compensate for the money that it costs to conduct a partial trial. The jurors' counsel in those proceedings, the contempt proceedings, declined to comment. Now, in the underlying criminal case, the jury was impaneled to decide. The New Jersey U.S. Attorney's Office alleged that the defendant resisted arrest when ICE officers came to his home in December of 2017 to execute an administrative arrest warrant and to initiate immigration proceedings. Now, the man at the time was a lawful permanent resident, and he said that he was not resisting arrest, but merely reaching for a coat because it was early in the morning and he's dressed in his pajamas. One ICE officer experienced an injury to his hand in the scuffle inside the house, And so the man was indicted for assaulting a federal officer. And that's the argument. So the man says, I didn't assault him. I was trying to grab my coat and a scuffle ensued. And they're saying, no, he was somehow trying to resist and he injured an officer. So that's what juries are there to decide. They decide whether that version is correct or that version is correct. But meanwhile, they got to follow their instructions. The criminal trial was originally scheduled for July 2020, but was delayed because of COVID to June of this year. Prosecutors and defense counsel presented 2 days of testimony. They made their closing statements on the morning of June 15th. I'm not meaning to be nitpicky here, but technically speaking, it's opening statements and closing arguments. But they made their closing arguments on the morning of June 15th. The jury's deliberations came to an abrupt end that afternoon when juror number 7 informed the court officer that another juror had disobeyed the judge's instructions and had conducted online research. The first juror didn't know the other juror's name, but in sworn testimony, Juror 7 told Kugler that the other jury member had looked up the logo on the officer's uniform the night before deliberations began. When the jury took the case, that juror said, the other juror asserted that his research showed the ICE officer's patch was a white supremacist logo. And the judge asked, he said that to the whole jury? And then he said, what was the reaction of the other jurors? Juror 7 said jurors weren't influenced by that assertion because no one knew if it was true, but they were distressed about the violation of court orders, the juror told Kugler. Everybody was upset that he didn't listen and he did that research. After that juror testified, prosecutors and defense lawyers agreed that there should be a mistrial because the juror's actions had tainted the jury. The judge asked whether he should also take action against the juror, and the prosecutor said yes. We would ask that you bring him in, put him under oath, and question him since he's in contempt. The judge asked only a few questions of the juror that afternoon, confirming that he understood that he was not to conduct research, and that he nevertheless Googled the logo and told the other jurors about his findings. The judge told the juror he would have to come back to court for a hearing on his actions and said, you may have committed a serious offense against the court, warning him he could face serious ramifications for defying court orders. And then the judge later told lawyers in the transcript, this is awful. It's an awful situation. So Kugler said at the June 15th hearing where the man was penalized, this is a huge, huge problem. And then he said, perhaps his imposition of the $11,000 penalty will help solve it. So jurors are always tempted to do more than they're supposed to. And we hear stories about this where a person gets on the stand and testifies they did something. I picked something up. I pushed something. Something fell over. And you hear about jurors back in the room deliberating. And someone says, could somebody really pick something up like that? And so then somebody goes, well, let's experiment and see. And so they try to recreate something. And the jurors are told specifically in their instructions, you're not to conduct experiments. You're not to go visit the crime scene. You're not to do any of these things. All you're supposed to do is go back there and deliberate, which is discuss, debate, argue, talk, and just go over the facts of the case and try to reach a conclusion on what you're asked to reach a conclusion on. And I've heard some stories where people would do stuff and you wonder and go, wait, it sounds like the jury's experimenting there. I remember a case a few years ago. It was featured on one of those crime recreation shows on network television a few years back, where a guy was alleged to have caused the demise of somebody near a cliff. And the argument was that the man may have had some kind of martial arts training. And somebody in the jury, I believe, said, I've got some martial arts training. And they started discussing this. Next thing you know, they're demonstrating how you would kick somebody to make them fall. You can discuss all you want. You can talk all you want. But the moment you start demonstrating it, you got a problem. And I know there are people in the audience right now are saying, Steve, let me get this straight. Sitting at home one day, minding my own business, and I open up the mail. It's a jury summons. Congratulations, you're a winner. Come on down to the courthouse and collect your prize. So you go down, you're sitting in a room for half a day. They call your name. Next thing you're being questioned. You're impaneled. You're on the jury now. Great. You got 3 or 5, 7, how many days of your life you can't get back. You're going to be sitting down there. Oh, whatever, fine, you're going to do it. You sit through a trial. Half the time you're leaving the courtroom so they can argue about stuff. They bring you back in, another witness, objection, disregard what you just heard. Very, very confusing, very, very annoying. it's not fun. I've met a few people who said they enjoyed it, but they're usually outliers. And so you get to the end of that, and they say, go in that room there and discuss amongst yourselves whether this person's innocent or guilty. Come to a conclusion and let us know when you're unanimous. And you're back there, and they've given you this whole ream of instructions. And by the way, the judge just read them. You probably didn't get a copy of them. They often don't give copies of jury instructions to the jury. So you may not have caught them all, but someone in there caught them. And so one of the instructions is do not do recreations, do not conduct experiments. And one of them is do not go visit the scenes of the crime if that's important. Because there have been stories before where a bunch of witnesses are describing what happened in a dark parking lot of a strip mall. Say there's a strip mall where the buildings go like this and then like this. There's a parking lot and there's a couple lights that are out. And the argument is about whether somebody over here could see somebody over here at 10 o'clock at night on a Sunday night. And a juror might be thinking, wait, why don't I just go there on Sunday night and take a look? Wouldn't that answer my question? It might. But there's also other things which get excluded from evidence for a reason, and they don't tell the jury that. And I've seen it before where going into a trial, both sides agreed, we will not go near this one particular issue. And it could be for a number of reasons why, but we're not going to address this one issue. We're simply not going to address it. Both sides agree. The judge knows about it. The judge agrees. If witnesses start getting close to it, they'll caution the witness. I've seen that before. And they also tell the jurors, if you have questions during deliberations, send out a note and I'll take a look at it and we'll see. I've seen the jury go back and send a note out immediately and go, what about this one issue? You guys, no one addressed this. What's going on there? So jurors can be very, very smart and pick this stuff up that they weren't supposed to pick up. But they're also told, don't go out and conduct experiments. Don't go out and conduct independent research. And one instruction will say, if you've got knowledge from your life and everyday experience, you can take that into account. But here we have somebody who saw a photograph of a patch. They thought they recognized the patch, but it wasn't what they thought it was. They went and they Googled it that night. And that was directly contrary to the jury instructions. And as a result, for the juror, Googling the ICE officer's mysterious uniform patch resulted in an $11,000 fine for contempt. Crazy story. Allison Frankel wrote it for Reuters. Vincent, John, Keith, Nathan, Gayla, and Jordan all sent it. Thanks a lot, guys. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If success were easy, everybody would do it.